Thanks everybody so much for joining us for the third in our four-part seminar series. Again, we hope that the information that we're providing to people in Louisiana and those of you that are joining us from elsewhere will deepen your understanding of the policy and legal environment that has shaped access to abortion. I'm Michelle Ehrenberg. I'm the co-founder and executive director of Lift Louisiana. My pronouns are she and her. We have a lot to cover today, but I wanted to start out for those of you who aren't familiar with Lift Louisiana and just telling you a little bit about our mission, which is to educate, advocate, and litigate for policy changes that will improve the health and well-being of Louisiana's women, their families, and their communities. Just a couple housekeeping notes. To minimize background noise, we have muted all participants and only our featured speakers will be using video. If you have questions, please enter them into the chat and my colleague Robin will ask them when we get to the Q&A. We have a quick poll to get your feedback at the end, and we hope that you'll take a minute to respond to it when we launch it. And finally, we are recording this seminar and we will post it on our YouTube channel later today. You can also find the recordings of past seminars there as well. So our focus today is on how abortion restrictions have been challenged in court over the past decades and how abortion restrictions can and have been used to criminalize pregnancy and people's bodies. I'm excited that we are joined today by two incredible experts in our state that are going to present today's topics. So who are they? Ellie Schilling is an attorney in New Orleans with extensive experience representing healthcare providers, and in particular, reproductive healthcare providers. She's represented clinics in enforcement proceedings with the Department of Health and in litigation to challenge laws and wrongful license revocations. Ellie also helped establish the Louisiana Coalition for Reproductive Freedom and is the co-founder and board president of Lift Louisiana. Born and raised in the Deep South, Mandisa Moore-O'Neal is a civil rights attorney, a Black radical feminist, and a supporter to grassroots women of color-centered organizing. By researching and analyzing the laws and policies that constantly control and stigmatize our bodies, sexuality, and reproduction, she helps to support the resistance to criminalization and reproductive violence and build the movement for reproductive justice. Mandisa will be joining us a little bit late today. So before I hand it over to our first speaker, I want to establish where we are in terms of access to abortion in Louisiana. For those of you who've joined us for previous seminars, this will be a review. Louisiana has enacted 89 abortion restrictions since 1973, the most of any other state. Any one of these restrictions can make abortion inaccessible for many people, especially those who have low incomes or face other barriers to health care. Not every restriction enacted in Louisiana or other states is in effect. Some have been struck down in court. And just so you know, our seminar next week on September 30th will go into way more detail about the impact that these restrictions have on how clinics operate and how patients access abortion. So please join us for that. The number of clinics in Louisiana has declined dramatically over the years. Between 2011 and 2017, more than half of the clinics closed in Louisiana, leaving the state with only 3 clinics left. Laws restricting abortion has made obtaining an abortion increasingly difficult in Louisiana through enforcing excessive requirements for doctors who perform abortions and the people who receive them. People have increasingly had to turn to the courts for protection of this constitutional right. So now I'm going to turn it over to Ellie to tell us more about the legal challenges to abortion restrictions that we've seen over the decades.
Yes, thanks, Michelle. Thanks to everybody for joining us today. Yeah, just to give you guys sort of an overview of what I'm going to cover today, I'm going to go through the seminal Supreme Court cases, looking mostly at how the landscape has shifted over the years. in terms of the standard by which abortion restrictions are judged and the way that the right is viewed. And then talk a little bit about current pending litigation in Louisiana and elsewhere and what we can expect given the most recent Supreme Court decision in June Medical Services, and also what this means with the recent death of Justice Ginsburg and how all of this would impact the constitutional amendment in that's proposed in November in Louisiana. So first, as I'm sure we all know, then Roe v. Wade in 1973 is the case that established that the right to terminate a pregnancy is a fundamental constitutional right. At that time, then Roe established what became known as the trimester framework. Basically what that means is that the court divided up by trimester, the types of restrictions and the ways in which states were allowed to restrict access to abortion. It roughly was understood, though, to be about pre-viability and post-viability. The beginning of the third trimester was then and is still now generally seen as the demarcation between when a fetus is viable, and meaning that it can survive on its own outside of the womb, and before that, pre-viability, that it cannot. So under Roe, then during the first trimester, then the state cannot ban the procedure, and the state could not enact any restrictions on abortion at all. It was a fundamental right, and in the first trimester, then access to abortion and how it would be performed, where it would be performed, was left solely up to the medical judgment of the physician and the judgment of the woman seeking the procedure. In the second trimester, however, the Supreme Court recognized that states may at that point have a compelling state interest in protecting maternal health. So starting in the second trimester, states were allowed to enact restrictions if they were reasonably related to maternal health. But it was not until after viability that the Supreme Court recognized that the state has a compelling interest in also protecting fetal life. So before viability, under the Roe framework, pre-viability, there could not be any restrictions that were based on the sanctity of life or convincing women not to have an abortion. It could only be health-related restrictions. But post-viability, the state could enact restrictions that are aimed at protecting fetal life, including by banning the procedure. A few things were important about this. Basically that the compelling interest issue in terms of when it kicks in, and that language basically set up what is called strict scrutiny, which is the toughest standard by which any constitutional right is judged. The state has to have a compelling interest, and it has to be legitimately related to the purpose that they claim they are pursuing. So restrictions on abortion under Roe were viewed with a lot of skepticism by the Supreme Court. And it was very difficult, in fact, for states to convince the court that the purpose was both compelling and legitimate. If we can go to the next slide. So next we come to Planned Parenthood versus Casey, which upheld the essential holding of Roe that there is a constitutional right to terminate a pregnancy. This was a very big deal at the time. It's really important, I think, to recognize that. Casey, as I'll explain, did water down and modify the Roe standard. But at the time, there was a whole lot of concern that the court had changed. The court was more conservative by that point, that the court would overrule Roe and say that there is no right to terminate a pregnancy that can be found in the Constitution. So that did not happen. Roe was upheld, and the fundamental right remained, but they changed the framework. So they got rid of the trimester framework, and they went with just a pre-viability, post-viability framework. There were some similarities, most notably in that pre-viability, the state still is not allowed to ban the procedure, and post-viability, the state can ban the procedure. But the most important change in the law with Casey is that the court recognized that throughout a pregnancy, the state has a compelling interest in both protecting maternal health and in protecting fetal life. So from the moment of conception onward, the state has that compelling interest, and they can enact restrictions during the entire course of the pregnancy if it is geared towards one of those purposes. So that basically opened the floodgates for all kinds of the restrictions that we have today, such as, you know, biased informed consent counseling that is really aimed at convincing women not to have the procedure, parental consent laws, all sorts of those types of restrictions were upheld in Casey specifically, and we saw sort of a plethora of restrictions like that after Casey. Including from the very beginning of pregnancy. So the first trimester was no longer off limits, and the second trimester was not limited to maternal health. So Casey also set up the undue burden standard. So rather than strict scrutiny, then after Casey, abortion restrictions are judged by that standard, and that remains today. The undue burden standard, what the court said is that a restriction cannot stand if it has the purpose or the effect of creating a substantial obstacle in the path of a woman seeking an abortion. So what does that mean? There's been a lot of litigation about that over the years. It's not a particularly clear standard. It's important to note too that a lot of the confusion that has resulted from that standard is because abortion is the only constitutional right that is judged by the standard. Undue burden does not apply to any other right that we have, whereas things like strict scrutiny or intermediate scrutiny do. So it's a new standard that only applies to abortion. Next slide. So then we get all the way to 2016 with Whole Women's Health versus Hellerstedt. And again, there was a lot of concern about what the court was going to do. Is the court going to water down Casey even more? Is it going to overrule Casey or overrule Roe? But in fact, Whole Women's Health was a very good decision for people who support a woman's right to terminate a pregnancy. The court again, you know, upheld and clarified that Roe is the law of the land as modified by Casey. But the big thing is that they gave a lot more strength and clarity to what the undue burden standard means. And the biggest part of that being that it's a balancing test, that with any restriction, then you balance the purported benefit of the law against its burdens. So if something has very, very little benefit, then it doesn't need to have a huge burden. It cannot just have a little bit of a burden, maybe. So that was something that there was a circuit split on before Whole Women's Health about whether the undue burden test was in fact a balancing test, or whether you just looked at the burden. So in the wake of Whole Women's Health, then for advocates for reproductive rights, then there was a lot of excitement that it would give people the ability to challenge a lot of laws that had gone unchallenged. Things that like smaller restrictions, for example, that may not individually create a huge burden, but that have no benefit. And also how all those little laws create a cumulative burden. So there was a lot of new litigation after Whole Women's Health, challenging old restrictions that have been on the books and challenging the cumulative effect of them. Specifically in Whole Women's Health also, then the Texas admitting privileges law that was identical to the one that was passed in Louisiana in 2014 was struck down, and the ambulatory surgical center requirements that would have required Texas clinics to upgrade their facilities in a medically unnecessary and prohibitively expensive way, both of those were struck down. So it was a very good decision for advocates for reproductive rights. Next slide. So that brings us to 2020 for the June Medical Services case, which, as I said, it's the same law as in Texas. It was an admitting privileges law that was at issue. It was the first abortion case to come before the court with Justices Kavanaugh and Gorsuch sitting on the bench. And what resulted was a plurality decision, a 4-4-1 split. So the traditionally liberal justices were in the majority for voting to strike down the law. The traditional conservative justices were in the dissent for, saying that they would uphold the law. And then Roberts alone wrote his own concurring opinion where he sided with the majority, meaning that the law was struck down, as we all know, but on a very, very limited basis where he did not agree with the reasoning of the majority. So he did it basically saying that Whole women's health is precedent. You know, we decided that case in 2016, even though he was in the dissent on that case. So he said, I don't agree with the result in that case. I don't agree with the reasoning in that case, but that is what we decided. And so based on that small limited thing, we're going to strike down this law as well. But in deciding to do it in that way, then Roberts significantly weakened the standard, meaning that, you know, he said that the reasoning that had been looked upon so favorably by advocates for reproductive rights of the balancing test, he said that he doesn't think that Whole Women's Health actually adopted a balancing test, and that if it did, he's not using it. So we no longer have 5 votes on the Supreme Court in favor of a balancing test. So we've gone back to sort of a muddier, weaker standard that was more, that predates Whole Women's Health. So what does that mean going forward is a huge issue. And we've already seen some evidence of how courts are going to interpret that. For example, a recent case in Arkansas just upheld a dilation and evacuation ban, which is the most common and safest procedure that's used in the second trimester, along with a whole host of other abortion restrictions that the district court had struck down under what it considered and what many people considered to be the proper reading of Whole Women's Health. So at the circuit court level in the 8th Circuit, then they said, nope, there's no balancing test. Roberts already told us that Whole Women's Health doesn't require one. And as he said also in his concurring opinion, you need to give deference to the legislature if it's an area of medical uncertainty. So they upheld those laws on that basis. So you can see that there's going to be confusion about what the new standard is and how it's going to be applied, and that conservative courts are going to take full advantage of that in overturning district court decisions. So that brings us to, next slide. So pending litigation. So right now there is a Louisiana challenge that was filed in 2016 to all of the laws that were passed that year. Those include a 72-hour waiting period, a D&E ban, the same as in Arkansas, so the most common, safest second trimester procedure, board certification requirements for physicians where there are not similar requirements for any other type of procedure, and medical experts do not even recommend them for first trimester abortions. And a genetic abnormality ban that is after 22 weeks, which is kind of strange because Louisiana has a 20-week ban. So it's basically just a tactical strategy to try to get a ban on the books. There's also Planned Parenthood's licensing case that is pending, which is a challenge to their the state's de facto denial of their license to be able to provide abortions. And then also a challenge to the Medicaid funding restrictions that were passed several years ago, which prevent any abortion provider from also providing care to Medicaid patients. And they actually expanded the law in 2017 that it can't even be it's specific to Planned Parenthood. You can't have an affiliate. If an affiliate provides abortions, then another affiliate cannot see Medicaid patients. Also, there was a case, a 2017 case here that was in the wake of Whole Women's Health that was challenging the licensing scheme that has been in place for years. Again, when people were feeling sort of optimistic about opportunities, then the plaintiffs voluntarily dismissed that suit recently, realizing with the new SCOTUS decision and the makeup of the court that it's not going to be a successful challenge. Across the country, we're seeing all kinds of laws being passed and litigation on things like gestational age bans, reason bans, and method bans. The most important thing to know about those cases is, one, there are many of them working their way up through the courts, and two, they are specifically aimed at overturning Roe. That is 100% the goal of those cases, of those laws, as opposed to like the admitting privileges law, which was, it was aimed at making abortion impossible to access, but not necessarily at overturning Roe. The other thing to remember about gestational age bans in Louisiana is that, I know Michelle told you guys a couple weeks ago, there have been several that were passed here, a 15-week ban and a 6-week ban but that did not go into effect because Mississippi had passed a similar law. And so they put this caveat in the one here that we'll wait and see if the Fifth Circuit upholds those laws. The Fifth Circuit did not, because it's so blatantly contrary to what is currently Supreme Court standard, the pre-viability, post-viability framework. However, as we get into new territory here with a new Supreme Court, then that very well may not be the case. The Supreme Court may decide to take, so far when those cases have been, the circuit courts have all knocked the laws down, and when the states have asked the Supreme Court to weigh in, hoping that they will overturn Roe, then the court has not taken those invitations, and that could change. And then we're looking at, gestational age bans, I think, proliferating all over the country. All right, I think I'm running out of time, but yes. So that's sort of, and we can answer questions on this. People may have specific questions in the question part, but what does this mean for the court in the wake of Justice Ginsburg's death? And how does a new court with a potential Trump appointee, how does that impact the proposed constitutional amendment here? I think, it's, to some extent, it's obvious if there is a new conservative judge on the Supreme Court, then it basically eradicates Roberts's role as an institutionalist, which is the only reason that he voted to strike down the law in June medical services, even though he did it in a very limited way. But with a fifth conservative judge, then Roberts's vote doesn't really matter anymore. And we could easily see Roe overturned, or we could see it just obliterated to the point that it doesn't really matter. For example, if you just get rid of the post-pre-viability framework, and you claim that there still is, on paper, there's still a constitutional right to abortion, but the Supreme Court starts upholding 6-week gestational bans when many women don't even know they're pregnant, then it doesn't really matter. So I think we could see the court take more of those cases, which they've been declining so far, because generally the court won't take a case if it's just squarely against its precedent. Because if there is a new conservative member, they're going to be itching to test out and limit a lot of these precedents. In terms of what that means here, it puts the constitutional amendment far more in play. And something that people really need to understand about its importance is that, if we're entering into a time where Roe could be overturned, or it could be limited to the point of being meaningless, then that's when state law is really going to matter. If the federal right drops away, then that's where the constitutional amendment here is really important. If Roe is overturned, then there's, as many of you probably know, there's a trigger ban in Louisiana and in, I think, about 12 other states, meaning that immediately then abortion will be outlawed. There's no exceptions for rape and incest, and there's only a very limited health of the mother exception. So that happens immediately. And if the constitutional amendment is also in place, it makes it very difficult, for generations to come, if we do get a more progressive legislature or a more progressive court, for people to pass protective laws, including even just rape and incest exceptions and protections. Because basically in a world without Roe, it gets sent back to the states. The issue gets sent back to the states. And if we have said that our Constitution specifically does not have a right to abortion, then it really limits what legislators can do to try to protect the right under state law. That's all I have for now. I'm going to turn it over to Mandisa, and then, yeah, happy to answer questions at the end.
Hey, everybody. As Ellie said, I'm Mandisa Moore-O'Neal, and my pronouns are she, her, hers. I'm a Black feminist attorney based in New Orleans and doing work across the state. First, I just want to say I'm sorry for my tardiness. I was actually on another Zoom panel actually talking about something that is connected to this, like the intersections of environmental justice and reproductive justice, and talking about like all of the reproductive challenges and injustices that occur in the context of environmental injustices and the ways that we live so close to Cancer Alley and what that means for births or not births and all, and like in people's health. So I just wanted to say I'm sorry as far as for being late. So thank you, Ellie, as far as for that introduction. I also don't have a PowerPoint, so I think this will just be more of an informal conversation. I'm hoping it's a whole lot of questions and comments, but the criminalization of abortion is something that ties in exactly like for all the reasons that Ellie said about it's something that we are increasingly facing as far as what might happen with the, passing like the vote on Amendment 1 and what's clearly seems to be in play at the Supreme Court. May Justice Ginsburg rest in power. But I also want to talk about the fact that even as we talk about increased criminalization of abortion, there is criminalization that's happening right now, even with Roe v. Wade still being the law of the land. And to me, it's a larger conversation about the criminalization of certain types of motherhoods, especially of Black women's motherhood, of brown women's motherhood, and of poor women across racial identity and their right to mother, as well as LBT right to parenthood is also criminalized. So I'm thinking of, have folks heard of Brittany Stevens? Folks can put in the chat, or I don't know if you can unmute yourself.
Yeah, folks can either put it in the chat, or you should be able to click on the little yes icon in the participant panel.
So Brittany Stevens was a mother who lived in the Baton Rouge area. And in 2018, she and her daughter, who was 1, were in the vehicle of a friend. And as they were driving, a car was in the wrong lane and hit them at a high speed. And several of the people in the car were injured, including her 1-year-old daughter. And, her 1-year-old was rushed to the hospital and later died. And in the midst of Brittany grieving her baby, she's charged with the same crime that the driver who hit them was charged with, which was negligent homicide. And this was based on the cops saying that the baby wasn't properly strapped in or something silly like that. And it was used as proof to in the wrong lane. And myself and a few other advocates, had reached out and tried to support that case. And luckily it was later dismissed, but it still caused so much stress to her and her family, as she's grieving. And it was a super interesting case in that it was like, what about Brittany, like this young mother, made you think that there was something negligent about how she interacted, like the experience that she, had. I also was thinking of, in 2013, a 17-year-old gave birth, and it was a stillborn. And while she's in the hospital in recovery from that experience, she's interrogated. And in the interrogation, it came out that a few days prior to her early birth, which resulted in a stillbirth, she had ingested a drug. And as opposed to engaging her in some sort of a treatment program, she was immediately criminalized, and in addition, charged to, I think it was 2 drug charges. She was also charged with feticide. Also in the Baton Rouge area, though this happens all across the state. It so happens that these 2 cases were in the Baton Rouge area. So these 2 cases are super interesting to me, and that they're not that far apart in time. They aren't that far apart in age, and that Brittany or Miss Stevens was 20 and this person was 17. And both were young Black women. And I think that these cases talk about something that, again, in the context of Roe still being the law of the land, it exposes some of the things that we know are going to increase in the event that Roe is finally overturned, which is what folks seem to have been working for, and Amendment 1, is passed. We are going to see people who've already experienced criminalization in instances where, we can talk about drug use and we can talk about, whether or not somebody is pregnant and should be using drugs. That's a conversation to have. And I hope all of us could agree that an answer to that drug use is support and rehabilitation and not further criminalization. And to me, it really illustrates that we're going to see a rise in these things. Unfortunately, if we talk about criminalization in the US, whether it be criminalization of abortion, or if it is the criminalization of sex work, or if it is the criminalization of certain types of drugs, like if it's a criminalization of HIV, there's no issue that involves criminalization that's not going to have a disparate impact on Black people in the US, on brown people in the US, and on poor people across races. So at the same time that we're having this conversation about what could happen in the context of Roe and with Amendment 1, with all of these, changes in the Supreme Court, I think it's also important to talk about who's going to be the most impacted in terms of who, and I hate to have this sort of dreaming because it's kind of a nightmare, but let's say in 2 years, if it is illegal and the conservatives get what they've been wanting, who are the people who are going to be charged with these things? It's going to be the people who are disproportionately charged now. If you live in Orleans Parish, if we go to Tulane and Broad, you would think it's only poor Black people who engage in drug use. You would think it's only poor Black people who smoke weed. And I bet a lot of people on this call may engage in that. And nothing's wrong with that if you do. But we have to acknowledge that who is arrested and who is charged isn't always the same as the people who actually engage in some activities. That same thing is going to be true of what's happening in terms of abortion access. So it's not to say that everyone shouldn't be involved, everyone shouldn't work to shift this, but it's also important to be clear that it's certain people who are fighting for this because they understand now what it means to be targeted and understand that that target is just going to increase in the event that these things are happening. It's also this ways in which we have to just understand and contend with is certain ways that parenthood is seen, and it's certain ways that people's parenthood is more often called into jeopardy and the impacts that it has. again, tragedies happen, and how are the ways in which these tragedies used to further cause pain and to criminalize people. So that's brief, so I'm hoping it's some time for questions, but just wanted to give that small overview.
Can I comment?
Of course.
Well, when you were talking, it made me think too that, you can sort of see this really, that type of criminalization as like a direct outgrowth of Casey and of the laws that were passed in the wake of that decision. Basically that women can't be trusted, viewing women's judgment as flawed or skeptical. And so that's why, the state is allowed to give you all this biased information, try to convince you to change your mind, and then second guess, everything that you did. And also giving the state license to promote and protect fetal life over any other interest that, would similarly be at stake. So I think you can see that shift as a direct outgrowth of the reasoning of that case and the laws that were passed since Casey.
I also think that context matters. Like, I think like of how you named Ellie in terms of the makeup had shifted in 92. In 96, 4 years after Casey, the Personal Opportunities and Work Responsibility Act, also known as the Welfare Reform Act, drastically changed how we even conceptualize of public benefits. It drastically shifted how we think of what is wrongly called public entitlements. I believe like that same context, is connected to Casey, like of this idea that women, particularly like poor women, particularly Black women, particularly brown women, must be controlled. So like on one hand, they can't be trusted as far as what to do with their bodies in terms of abortion access. But on this other situation, some of them are having too many children. And so it has to be controlled in these other ways that actually have nothing to do with who's in need of assistance and things like that. So I think that like all of that context also plays into why we have these various laws impacting people's right to not have a child and to just live in worlds that are free of like criminalization. So yeah, like I appreciate that context. I think of Casey and then 4 years later, welfare reform. Like I also think of Casey at the same time as the 1994 crime bill, right? In the ways in which we, in hindsight, perhaps can see how the war on drugs and mass incarceration were in fact wars on entire neighborhoods, on entire groups of people, entire portions of cities. And maybe at the time, we didn't see that. We were like, oh, well, it's good to be tough on crime, maybe. But let's be clear, people at that time were still fighting it like, this is not about crime. This is about you profiting off of putting people in cages. So I also think that like the 90s was wild. Like, folks talk about fashion and music. You had 92 Planned Parenthood v. Casey, 94 crime bill, 96 welfare reform act. Like you had some wild shit happening that I believe we're still seeing the impacts of on communities and entire groups of people. 90s were wild for many reasons, apparently.
Yeah, no, I think that there is a through line, that's both about control and also not trusting people to be able to make choices that are right for them, their families, their communities. Yeah.
Several questions. So Robin's gonna shoot some at you guys.
I just want to make a comment. First of all, I want to thank Ellie and Mandisa for this excellent information and lift you guys up. I too had a similar case in terms of criminalization against Black and brown people for, you know, some of the stuff that happens to all people, but we receive harsher treatment for it. The years that I was in Georgia doing organ donation as a designated requester, I remember being in a hospital in Columbus, Georgia. 17-year-old man, 18, 17, he and his girlfriend were coming home from their late jobs, had picked up the babysitter. He fell asleep at the wheel and got T-boned. And I so vividly remember the baby got hurt, ultimately progressed to brain death. And I remember him crying, wailing in the nurse's station. I'm sorry, saying to his son, while the police had come in to put handcuffs on him to drag him out of the ICU unit. And we have to lift this stuff up, Mandisa, and everybody else who is engaged in wanting to do good work in this reproductive justice field. We need to let these stories be known. So I'm gonna delve into the questions because there are several for both you and Ellie. So we can start chatting this up because this is important stuff here, okay? Thank you. All right, let me go back. Okay, this question, Mandisa, is for you. Do you have any ideas about policies that could be enacted that would protect people from being interrogated, prosecuted for losing a pregnancy, either by termination or miscarriage?
Policies that are in place or policies that need to be in place?
Policies that could be enacted that need to be in place, yes.
Oh yeah, well, right now, like we have again, because we are a right to life state, which we know is code for certain fetuses and not life as it exists after birth, because our state doesn't fund any of the things that actually ensure people, you know, have higher qualities of life, like housing, education, roads, none of those things, except for incarceration. Like we fund that a lot. We have a very robust feticide law, which, you know, in my experience is very, very broad. And it means that situations that is not like, not to get into this, but there is general intent and specific intent. And the purpose of general intent is that something happened and I was a part of it. Like, I don't have to show that, like, I meant this thing that happened. And specific intent is when me being a part of something isn't enough to show intent. Like it's not enough to say I knew or should have known. I have to show, like, it has to be shown that I actually meant this thing to happen. I believe that it is dangerous to have a general intent feticide law because it means that all of these cases that are disproportionately impacting poor people across race, particularly Black people, particularly brown people. So I think that having a specific intent law is a way to make sure that, like, it's protecting people. I also think that there are advocates in this state that aren't listened to. Like, I know our governor loves to have a task force on everything. And so I think it's something, you know, in terms of it's some task force already that exists on this issue. I think that it should be something that they have been mandated to actually focus on and, again, work out ways. I also think there is more funding that needs to be allocated into pregnant specific drug rehabilitation programs in terms of, I don't believe the answer is criminalization, but I do believe that the answer is more support and resources for pregnant people who are experiencing out of control drug use, which, again, that question then goes to what is the healthcare access that people who are pregnant have?
Right, right.
If I could just add real quickly to that, then yeah, I think that, I mean, one of the other problems with why prosecutions like that are dangerous and broad is that there's often not any clear causation either. And like you, I wouldn't be in favor of people being prosecuted even if there was clear causation, particularly for things like drug use that people, you know, they have a medical condition and they need help. But the problem is that that's not even how it's happening. So,
Exactly.
you know, statutes and policies need to be limited, at least in that way, because it's basically back to, again, like suspicion, you know, and not trusting certain kinds of people in particular, you know, that like we found out that you did drugs. So that must mean that that was the cause of you having a stillborn, which is probably actually a very tragic event for the person experiencing it. But if it's somebody who wants to criminalize that person, then they just jump to a lot of conclusions.
Oh, and
that aren't medically supported.
Racist. You know, it's especially racist, especially in a state that has disproportionately high Black child and maternal health outcomes, where Black women are more likely to have lower birth rates, all of these things. So if you're saying, like you said, Ellie, well, if your child was stillborn and we know that in the past you've smoked crack, therefore you smoke crack and that's why your child was stillborn, how is that setting up people who already have these well-documented histories of higher, you know, low birth rates or things like that?
And then the issue of smoking crack as opposed to taking, you know, oxycodone. It's still a drug, okay? You know, you want to be rehabilitated if it's an opioid crisis, but you want to be criminalized if it's crack. You know, okay, I'm getting political here. Let me move on. Question for Miss Ellie. How could Louisiana Constitutional Amendment 1 impact future abortion legislation? And can it be challenged in court?
So the way that it could impact future legislation is just that it will be a very limiting principle. While there still are federal protections, then it won't have a real life impact in Louisiana. But it definitely has a tone, right? Even with federal protections, part of what we're very concerned about, of course, with this, if this amendment passes, is that it will embolden the legislature to say, see, we told you so. You know, X number of percentage, this huge amount of people in Louisiana are pro-life. And so we now have carte blanche to pass whatever restrictions we want and see if we can get the Supreme Court, you know, the US Supreme Court to go along with it. But if federal protections fall away, then it will be hard to ever pass any laws here that protect abortion access, including that, you know, the proponents of this law keep saying that they didn't include rape and incest exceptions because those can be added. The legislature can later, you know, add those exceptions, even though they're not in the trigger ban. So they would literally have to be legislatively passed, which we couldn't get through on the amendment. We couldn't get through on the 6-week ban, the 15-week ban. And if the amendment passes, then it sets up a very real possibility that a court will say that those laws, those exceptions are unconstitutional under the state constitution. And I do not think that there's much of a viable court challenge, unfortunately. We can't, it's not something that is being passed in relation to federal law. And if our state, if we had a more liberal judiciary to date, particularly the Louisiana Supreme Court, which is why those elections also really matter, then some states already have developed fairly robustly in their state constitutions that the state right to privacy does protect things like abortion access, which is what the proponents of the amendment are trying to front run. They're trying to make sure that that never happens by putting it in the Constitution that absolutely the Constitution does not protect abortion. So because the jurisprudence that here has not really been fleshed out, then we don't really have the basis at this point to say, no, this amendment is unconstitutional because these are the rights that our state constitution has already been interpreted as providing.
Thank you.
I don't know if you want to add anything.
Also agree with Tone. Like, my fear is that it sets a legal precedent, but also like political tone that birth control and other rights of contention that maybe, you know, in the past under other administration folks have felt were too extreme. I think folks have gotten the memo very loud and clear, and it's very well funded by the opposition, that now is the culture to kind of do these things that maybe we've only dreamed about or thought could only happen in other situations. So yeah, I think that the impact of Amendment 1 extends well beyond if Roe is eventually overturned.
Thank you. We have another question. One question is, the language of Amendment 1 is confusing. Do you both think it is poorly drafted, or did they make it confusing on purpose?
B.
And the follow-up to that is,
Yeah, B. And it's not just Amendment 1. Like, there's a history of our state using double negatives and I don't know what it's called in grammar, like, but lots of like small phrases inside sentences to like confuse people in ways that I know in the past, I'm trying to recall which one, this was like in 2005, in which folks who were actually in support of something had voted against it because of how it was worded, you know, and the use of the double negatives. So it's a strategy that's been super impactful in the past. So yes, B, capital B.
Yeah, and I would just add to that they, I mean, not surprisingly, because they are well funded and they've been planning this for some time, then you know, they crowdsourced, they did polling on different potential language. This is the one that they landed on, the language they landed on that was most appealing to their supporters. And I think in particular, to me, it's the insertion in the middle of that to protect human life.
Yeah.
Then that's sort of like, that's the part that jumps out. And then you just sort of like gloss over the rest of it. But the wording is intentional. So it's not poor drafting, meaning they're just bad at their jobs. It was crowdsourced that this is the best wording for them.
And the funding of abortion, I think, was intentional in terms of, you know, those are some conversations that I've been having with some people who, you know, are like, well, I'm for abortion, but I don't understand why state funds. And it's like, okay, let's have a conversation about like what that means and what it does not mean. And so to me, like the clause to protect human life, like you said, and the funding of abortion is definitely meant to maybe draw some people who in a state were like, we're literally fighting over crumbs.
Yeah, no, and there's also a huge misconception, as Mandisa, I'm sure you know, and many people on the call, that lots of people in Louisiana and elsewhere think that taxpayer dollars are used for abortion services.
Yeah.
So that it's always appeals to people, this, you know, so any sort of prohibition on that, even though the law is already prohibits, both state and federal law already prohibits any taxpayer money from being used for those purposes.
So why do you have a sentence that says funding of abortion? It implies that funding is something that already happens.
Right. Exactly. And the other part of that is that it's, again, a front-running strategy. There's at least been one state, there might be more than one, that interpreted their state's constitution as preventing that state from prohibiting state funds from being used to provide abortions, that there was like an equal protection issue or right to privacy issue. And so, you know, that freaked out the people who drafted this amendment. And so they want to make sure that, you know, the state Supreme Court is not at some point going to interpret other provisions of either statutory or state constitutional law to say that, okay, the federal ban, the Hyde Amendment's in place, but for our state, then that's not the law.
Okay, you guys, these are really, really good answers, and as confusing as some of this can be, this is the stuff we need to hear. But we got like 2 or 3 more good questions, and then we got to wrap. So I'm going to speed through this. The next question is that it says that we have a considerable number of anti-choice legislators in Louisiana. Do you guys think that they actually are an accurate representation of the citizens' views on abortions? And there are an even number of Democrat legislators in our state that are anti-choice. It seems more than any other state. So how concerned are you guys that the amendment is going to pass?
I can take a quick crack. I mean, I'm very concerned that the amendment is going to pass. In terms of the legislators, I think it's a bit of a mixed bag. I think some of them are true believers. I think some of them they're very much afraid of getting the bad scorecard from the family forum, and they don't hear from constituents that do not share very extreme pro-life views. So some of them, I think it's sort of a matter of expediency. It's both.
So I think that people, just FYI, I don't use the framework of anti-choice and pro-life. I think that's framework that actually the right started, and that we kind of find ourselves entangled in, because I don't know anyone who believes in abortion who's not also invested in life.
Right.
Just putting that out there, like, we're all for life, and part of why we're strongly in belief of abortion access is because people deserve to live their full whole lives as they choose. And it's actually the people who are supposedly pro-life who have histories of supporting policies like they're literally killing people. But with that, so to me, like, that's the context that I think a lot of these lawmakers are in, of they are supporting policies that they know kill people, at the same time that they're saying we support this right to life. I also think that there's a lot of propaganda that people are invested in perpetuating. I also think that legislators, both Dems and Republicans, have shown they have an unrelenting commitment to white supremacy. And even if it means other white people are going to be impacted by this thing, their commitment to white supremacy is actually higher than, this is ironic, I know, is actually higher than their commitment to other white people. I know that sounds wild, but I hope it makes sense what I'm saying. Like it's a history of people who have voted against their interests. I also think that it's this way in which some people are trying to acknowledge of forced sterilizations that get lost, and therefore feel that the way that you acknowledge histories of eugenics is to be against abortion access. And so they think, okay, well, I'm a Black person in the South who knows very well, very intimately, these histories of not being able to have children the way that I want. And so therefore, anything that is saying somebody has the right to abortion must be stopped. And as somebody who also acknowledges that history, and as somebody who is very in favor of right to abortion, I believe that it's not an either or, and it's possible to acknowledge these histories of forced sterilizations and these histories of not being in control of your body, and that you do that by not controlling someone else's body.
Right.
So
okay, we're a little bit over.
Yeah.
There's one very interesting question here. Miss Linda sent that it says yard signs are popping up on the North Shore in the Abita area saying vote no for the constitutional amendment. Shows a very pregnant female holding her. I'm sorry, I read that wrong. To vote yes for the constitutional amendment.
Oh, I was intrigued.
Yeah. And it shows the sign of a very pregnant female holding her stomach. And it says protect babies. How can this sort of marketing be addressed?
Well, I think that people can join the coalition that is currently producing marketing in support of voting no. I also think that sometimes like folks want to talk to people who are very different from them and talk to people who are not close to them, you know, and move to another city and talk to them. I also think talking to our own family members, talking to people who are actually like, I talk to my mom about stuff all the time and she's very into abortion, you know, because I feel like, how can I go talk, you know, with Ellie about something and my own mama is sitting around saying some wild shit about abortion?
Yeah.
Honestly.
Yeah, no, I think that's right. Sorry, I didn't mean to cut you off.
No, go ahead.
I was just going to say that I think also one way to message about this, particularly to people who are skeptical and or might at this point think that they want to vote yes, is like you know, would you want that? Do you think that you have the right to make this decision for your neighbor? You know, what if your neighbor was like the victim of rape? Then shouldn't your neighbor be able to decide for herself, you know, what is right? I think like shifting it away from it being about the person.
Absolutely.
People can decide whatever they want for themselves. Nobody is, again, it's always like some of that with you know, anti-abortion stuff. Nobody's telling people that they have to have an abortion. So it's not about what you would do.
Mm-hmm.
You may have your very strongly held beliefs. It's about, do you think it's right to tell your neighbor that, you know, that they can't have theirs, no matter what the circumstance, which you may not know or understand.
I think that's so effective.
Well, there's one last question about whether or not this marketing, I guess, about these yard signs can be shared with the group. And Michelle is steering everybody, and I think this is wise. Sign up for the Louisiana for Personal Freedoms campaign, and you can get more information about pretty much all of this. Want to thank everybody for participating today. This was a great conversation, and I think that's what the Women on Wednesday series, you know, is trying to do. Thank you, Ellie. Thank you, Mandisa, for all of your expertise and sharing this information with us. We have the abortion access seminar and poll. We want to make sure that you guys, you know, take advantage of that and filling that out. We look forward to talking to you guys and having another great conversation on next Wednesday. So you please join us then. Again, thanks everybody for participating and have a great day.